Good morning on this bright day in Chautauqua. I am so delighted to be here on a day scheduled for two very special events. The first is the Pacifica Quartet's recital at 4 this afternoon. I am very proud that my son, who makes classical CDs, has produced exquisite recordings of the Pacifica, playing Mendelssohn's and Shostakovich string quartets. The members of the quartet are extraordinarily gifted, energizing, altogether engaging young artists, as those who attend the recital will agree. Second, tonight, Falstaff, the very last opera Verdi composed, and will be performed this evening. Verdi was 79. For 4 centuries, opera has transported audiences who come as I do to the music, the stories, the singers, the drama, or as Falstaff illustrates, the comedy. So I will speak of law and lawyers in opera. My confidence to address this topic is not altogether apparent because, if truth be told, I am ill-equipped to break out in song. My grade school music teacher ranked me a sparrow, not a robin. I was instructed, do not sing, only mouth words. Still, in my dreams, I can be a great diva. I can be, most often, Renata Tebaldi, sometimes Beverly Hills, or Marilyn Horne. My performing career begins and ends with the Washington National Opera, where I have 3 times appeared as a super. I debuted in 1994 along with Justice Scalia in the production of Richard Strauss's Ariadne auf Naxos. We were supers again in the same opera in 2009. And in between, in 2003, I was on stage in Johann Strauss's Die Fledermaus at Prince Orlovsky's ball in the lush second act of Fledermaus. 3 black-robed justices enter on stage as specially announced guests billed as the Supremes. Flanked by Justice Kennedy on one side, Justice Breyer on the other, I had the extraordinary opportunity to hear another guest at the ball, Placido Domingo, to hear his glorious voice at very close range. Well, lawyers and judges, as a rule, fare not too well in operatic works. And that judge, well equipped to try the breach of promise of marriage case, decides the case had better settle than proceed to trial. So his solution is he tells the lawyers to put their briefs up on the shelf. He will marry her, the plaintiff, himself. And Iolanthe. And he used as the model for the robe, for the new robe that he sported one morning, the costume worn by the Lord Chancellor in a low-budget production of Iolanthe, presented summers ago by a local company in D.C. Now you're about to hear a selection from another Gilbert and Sullivan And so if you go by the strict text, Frederick is indeed a little boy of 5, but if you take a purposive view of the law, he looks like he's 21, and that carries out the meaning of the contract, I think, far better than the liberal textual interpretation. I have 2 final comments about opera tied to the Supreme Court, and then I will invite your questions. In 1988, Justice Harry Blockman arranged the first ever afternoon of music at the court. Initially, the recitals were held every other year. When Justice Blockman retired and Justice O'Connor took up the baton, the program became an annual event, and since 2002, when I picked up the reins, the event occurs twice a year. We timed the May musicale just before the pressured late May through June weeks when the justices are consumed with producing all outstanding opinions, because we don't recess for the summer until everything that came in the first week, the first Monday in October, is released to the public. We have no backlog. We start each new term fresh. Talented composer and June graduate of the University of Maryland Law School, Derek Lang, is composing a comic opera, runs not more than 1 hour, titled Scalia Ginsburg. I was asked about that title and said, the question was, why not Ginsburg Scalia? My answer is, first, Scalia Ginsburg sounds better, and second, in the court, everything is done by seniority. And although I am 3 years older than Justice Scalia, he was appointed several years before I was. So, by seniority, it is Scalia Ginsburg. Well, many of the lyrics come from our opinions and speeches, and I will give you a sample from Justice Scalia's Rage aria. I wish I could sing it. It's written for a tenor voice. You get the idea if I just speak the words. The justices are blind. How can they spout this? The Constitution says absolutely nothing about this. And then here's one from my opening aria. Dear Mr. Justice Scalia, you are searching in vain for a bright line solution to a problem that isn't so easy to solve. But the beautiful thing about our Constitution is that, like our society, it can evolve. And the theme of the opera, with some borrowings from the Magic Flute, is about 2 people with notably different views on constitutional interpretation, who nonetheless respect and genuinely like each other. It is collegiality of that sort that makes it possible for the court to do the ever-challenging work the Constitution and Congress assigned to us without the fierce partisanship that sometimes mars the operation of the political branches of government. And now, with an appreciation for your very patient audience, I welcome your questions. It is interpretation of the words of the statute. People who take that view are concerned that if judges don't adhere rigidly to the words of the law, then they will be making it up, they will be projecting their own will and not the will of the legislature, and that's a dangerous thing, because no one elected us to pass laws. That's, I think, the view that textualists would give, would offer to explain why they think that the text itself must be what's followed. My view is that the laws that Congress passes in great quantity are not always clear and certain. Sometimes there are unintended ambiguities. Sometimes they're deliberate because it was a political hot potato and the legislature wanted to pass the vote to the courts. So I tried to follow what I think was Congress's purpose in enacting the law. So it's the words that they use informed by the purpose of what they were trying to do. And so that's why I disagree with a strict textualist approach. But I do recognize that it is the legislature's call, and that's why I tried to fathom what the legislature was trying to do, what it really wanted.
So I'm not sure about the propriety of this question, but I'm sure you get it all the time. What can you tell us about the deliberations with your peers over Bush v. Gould?
They were exhausting. The court granted review on a Saturday. Briefs were filed on a Sunday. The case was argued on Monday, and opinions were out Tuesday evening. So it was a marathon for all of us. I was not exhilarated by the decision, but I was surely exhausted. It was my view, and I can be frank to say this because I dissented. I thought the court should never have taken that case. You know, so many of the questions we get are really what I call who decides questions. And that one, I thought the Constitution provided, in case Florida didn't settle it, then it would be the House of Representatives. The Constitution empowers the House to determine contested elections. I should add to that I don't think the end result would have been any different, because the House was then had a strong Republican majority. So Bush would have been our president in any event, but it would have been decided later rather than sooner.